Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello, and welcome to the third episode in our podcast series about artificial intelligence and legal professional privilege, where we discuss the impact of AI on this privilege. I'm Lauren Saparovich, Special Counsel at Hall & Wilcox, and I'm delighted to be your host for today's episode. For those who tuned into previous episodes in this series, my colleague Katie Moore and I have discussed the topical and evolving question of whether the use of AI can waive legal professional privilege. In today's episode, we'll be discussing how AI is impacting legal professional privilege, focusing on how the issue is being approached in Australia as compared with the United Kingdom. And to do so, interestingly, we have a very special guest. I'll have the pleasure of speaking with a former colleague from my time working in London. So I'm joined here today by James Shiel, Principal Associate from Mills & Reeve in the UK. James is also a litigation lawyer with broad experience in commercial disputes. Welcome, James. Thank you very much for joining me today.
Good morning, Lauren, and thank you for having me on your podcast.
Thank you, James. So I thought it was a great idea for us to explore the current positions in each of our respective jurisdictions. So in today's episode, we're going to discuss the emerging positions in both Australia and the UK with respect to the use of AI and its impact on legal professional privilege. As we, of course, all know, AI is transforming the way we work, and the judiciary in Australia, as appears to also be the case to a different degree in the UK, is only really just starting to consider the impact of AI on this privilege. Now, obviously, we expect this space to be fast evolving, noting the current message from both jurisdictions is that practitioners should beware when using open or public AI. But obviously, much more work needs to be done to unite guidelines and respective positions and bring uniformity. Now, James, can we kick off by getting your thoughts on the use of AI? Obviously, a very narrow and confined question to start, but anything you have to say to start us off, please?
Yeah, absolutely. So I think similar to in Australia and elsewhere around the world, we're seeing AI chatbots and large language models now being routinely used to draft, summarize, and analyze documents, not only by litigants in person, but also clients and lawyers alike. We don't yet have all the answers in England when it comes to AI and privilege, but the short answer is, though, that the AI and privilege landscape in England looks very similar to what I understand the position to be in Australia. The big watch out is, as you mentioned, that public AI tools with confidential or privileged material is something to be aware of, because that's where you run the most obvious risk of potentially waiving privilege. And what's interesting is that, like in Australia, we don't have a single definitive decision saying that AI use automatically waives privilege. Instead, what we have is judicial guidance and tribunal level commentary, which actually means that this is an evolving area for practitioners to grapple with. And I'm guessing, Lauren, that picture and potential uncertainty is what you're seeing across Australia too.
Very much so, James, and we'll get into that when we compare the two different jurisdictions, but it does appear the UK and Australia are quite aligned in terms of where they're at with judicial consideration. So just to set the scene regarding the use of AI and its effect on this privilege, it might be worth just briefly refreshing ourselves on first principles of the privilege and how they differ or overlap between the jurisdictions. Of course, legal professional privilege is an essential safeguard in the legal system, and it does apply both in the UK and in Australia. And it's a right that belongs to the client. The maintenance of client confidentiality is also a fundamental duty of the professional standards of Australia, and I understand also of English solicitors. James, can I ask, can you explain how legal advice privilege and litigation privilege work under English law, and also the centrality of confidentiality to your jurisdiction?
Yeah, absolutely. So the starting point is that the default position is being that a party to litigation must, as part of any disclosure, produce all materials relevant to the issues in dispute, except those protected by privilege. So very briefly, English privilege is built around two main concepts, as you mentioned, which broadly map onto what Australian lawyers would also recognise. So the first being legal advice privilege, which protects confidential communications between a lawyer and their client for the purpose of giving or receiving legal advice. And an important point to note that is in England, we narrowly define the client, especially in corporate settings. And the second form of privilege is litigation privilege, which is broader and covers as well confidential communications between lawyers, clients, but also third parties, but only once litigation is reasonably contemplated and the dominant purpose of the communication is the conduct of that litigation. So a unifying theme, as you mentioned, between legal advice and litigation privilege in England. And this, by the way, is where we've seen the debate between AI and privilege really bite in this jurisdiction today. Is confidentiality. Lose that, and the risk is that privilege will go with it. So that's the English framework around privilege in a nutshell. And again, I'm assuming that's how it plays out in Australia too.
Yes, as we tend to adopt what England has done in that regard and the mother country, yes, that is very similar to Australia. We particularly have the dominant purpose test for both legal advice privilege and litigation privilege, which appears to overlap with the UK. And for us, as I assume is probably your situation, both forms of these privilege, the legal advice privilege and a litigation privilege, are enshrined in legislation at both a federal and state level, as well as in common law. So it's a deeply entrenched form of privilege and right for a client. With this quite consistent position as our base, if we come back to the use of AI and how that intersects with this privilege, disclosure then to a third party of any sort, including a server, may waive this legal professional privilege as it results in the dissemination of information and of confidential information, as you've so rightly said. And the undermining of the confidentiality in the document or communication really will waive privilege if that confidentiality is undermined. So really the risk of waiver is compounded by the functionality of this AI, and particularly public or open AI. And my understanding is that specifically the case in open AI tools such as ChatGPT, because their terms of use grant their platform perhaps broader rights over things like user inputs or storage or ability to process or use that information again than perhaps people are aware of, and we're trying to make people more aware of here. So really, if confidential client information or material is uploaded, it can be retained on these third-party servers, and this loss of control over the information is really fundamentally inconsistent with the maintenance of privilege, but the maintenance of our confidentiality regime and duties as solicitors in Australia, and I assume the same in the UK.
Yeah, I mean, that's absolutely right. And it's that access point, but also the concern around, can these third-party systems learn from the material that's being put in there? So one, it's a privilege point. You don't want legal advice being disseminated to a third party, but also just around confidentiality as well. Putting confidential information into these third party systems might not necessarily be the best thing to be doing from a privilege perspective, but also the concern around shadow AI as well. That the idea that potentially these systems are learning and getting background information from the information that people are putting in there without necessarily people being fully aware of those consequences.
Exactly. And then that, I think people perhaps aren't aware that in so learning, they're using what they've learned, perhaps from your information or your client's information, to then respond to other people. So what you've put in, if it's not a closed system, or if it's an open or a public system, is not limited to what you've popped in, but is then extended to allow, as you've said, it to learn and it to then respond to other users. So that's why the terms and conditions and the level of closure, if you will, is really key for a practitioner to be aware of before they do upload any information.
And some of the commentary at the moment, which is all relatively speculative in its nature, but for example, there are some concerns out there around whether it's possible for people who are really technical to be able to reverse engineer information from these models by asking certain questions about certain potentially competitors of clients, etc., which again, it's things that will have to be bottomed out and thought about in those sorts of ways, but it's a big concern for a lot of companies and organizations at the moment, and not necessarily thought about necessarily at a more junior or employee level.
I agree. And similarly, I read somewhere that there was some concern, and people are starting to test or teach their juniors about the way that Chinese walls can be breached essentially by the use of AI. Because let's say, for example, something has put through AI in a closed system at a workplace, and years later, is that going to then create a conflict with a potential other client down the track if that's been used in an open system? Like, where the breadth of which this affects client relations, I think is only really starting to be considered.
Yeah, and absolutely. And I mean, the technical side of AI isn't necessarily appreciated by lawyers and people that are using these systems. It's effectively seen as something which is quite magical in how it works, and we don't fully appreciate how it actually works. And also the potential for technological change being quite quick in this area. It's very difficult for lawyers to keep pace with that. But we're talking about AI chatbots at the moment, but there's also coming down the track lots of potentially exciting developments around agentic AI and other areas as well. So it's a fast moving area which is very difficult to keep pace with.
Exactly. And I think that leads me to just raise, just so we have the scene set, about whether definitions have actually been created around these terms. Because as you've said, they're so fast moving that unless they're really clearly defined, we don't even exactly know what we're dealing with here. So recently there was a Victorian Law Reform Commission. So one of the states in Australia has released a report just in February. And that provided some definitions that we've been adopting and were recommended to be adopted more broadly in the state. But again, they're not super prescriptive as to how they define public or closed AI, but they give us some benchmark because, as you've said, this will surely need to be refined and updated as the technology updates. So at the moment, we've got public AI defined as an AI tool that's openly accessible to the public, typically via the internet. Now, that's not extremely prescriptive, but obviously these AI tools are trained on broad public data sets and usually for general purpose use, so things like ChatGPT, as opposed to closed AI, which is generally not openly accessible to the public, and the information used in closed AI tools usually remains within a controlled environment. So usually that denotes the requirement of controls to reduce risks related to privacy or confidentiality settings that protect information from being made publicly available, or, as we've talked about the significance of, or used to train that AI tool. But it'd be very interesting, as you've touched on, to see how these definitions changed and are honed as the technology changes, because surely it will need to be more nuanced to capture how the technology itself changes. So with that in mind, there's been a very juicy, significant case in the UK that you and I have been speaking about that deals with some of these issues in the UK. And my understanding is that it's the first judicial statement in England and Wales to address the relationship between AI use and legal professional privilege. Can you speak about this case, James?
Yeah, so that's correct. So this is where things have got interesting in England this year. I should say interesting in the context of AI and privilege. Basically, we have a couple of paragraphs in a judgment from the Immigration Upper Tribunal, which has generated a huge amount of commentary in England, but also elsewhere. Not because it finally settles what the law is, but because of its potentially strong messaging about AI and the risk around privilege and waiver. So the decision is a decision which is called the UK versus Secretary of State for the Home Department. It was published on the 19th of February this year. And it concerned a situation where a lawyer had uploaded confidential client correspondence as well as Home Office correspondence into public AI tools. The upper tribunal held that any regulated lawyer who does this must report themselves to their regulator and may need to consult the Information Commissioner's office. What this does is it reinforces good practice, but what it doesn't do is establish an automatic waiver of the client's privilege, despite comments in the judgment to that effect. So as I mentioned, in effectively one paragraph in the judgment, the tribunal said that uploading client correspondence into a public AI tool like ChatGPT is effectively putting it in the public domain, breaching confidentiality, and thus waiving privilege. And I'll hand back to you in a moment, Lauren, to get your reactions to this case. But from my perspective, this one paragraph or so in this judgment matters because, like you said, it's the first statement to this effect in a reported case within England on AI and privilege. It's also consistent with the October 2025 AI guidance for judicial office holders, which is guidance that has been developed to assist judges in relation to the use of artificial intelligence, which states any information that you input into public AI chatbots should be seen as being published to all of the world. And what's crucial for your listeners to understand is where this decision sits. So the upper tribunal's decision isn't binding on the High Court in England, so it doesn't settle the law, as I mentioned. What it does do is provide very strong guidance, particularly in the tribunal's own jurisdiction, and it's a clear signal of how judges are thinking about AI-related risks. More broadly, the UK doesn't have a single unified court system. England and Wales share one system. Scotland has its own distinct legal system, and Northern Ireland has another. Decisions in England and Wales don't bind the Scottish and Northern Irish courts, and vice versa, although they may be treated as persuasive. So when we talk about the UK position around AI and privilege, what we really mean at the moment is a developing patchwork of guidance and tribunal level decisions, rather than a settled and nationwide doctrine. And I'd be really interested from your perspective, Lauren, how this language lands with the Australian courts, and does it echo what you're seeing from the cases that you've seen in Australia?
I very much agree, James, because I think my understanding is that while there hasn't been an authoritative ruling by Australian courts, there has been recent judicial consideration that supports the position that uploading documents into AI could constitute a waiver of privilege. So I actually think Australia's position is less strong than the UK. Similarly, we have a framework that's been pieced together of some judicial commentary, again, similarly to the UK, a couple of sentences here or there in specific cases, and some regulatory commentary. Actually, it's growing, and it's growing quite consistently, but in the same way that you've said there's piecemeal discussions around the United Kingdom, our states and our various jurisdictions and levels within the states are not unified at all. So I might just give a quick recap of the position in Australia, because I think that's really quite key in seeing how we're, I think, a little bit more mild than the UK position at the moment. So it's interesting to see that I think in the same vein as in the immigration context of the recent decision you were mentioning in the UK, we're finding in Australia that the predominant commentary that's flowing from courts around this sort of AI and the use of AI in practice are often from self-represented litigants. And in our instance, it's the family court where we've got the most commentary. And again, that does make sense from a practical perspective, because people are relying on AI when perhaps they're not able to utilize legal representation in the same way. Though funnily enough, and we'll get to this on one of my next sessions where we unpack the US system, but there's been some recent judicial commentary in the US where actually there was legal representation and still this issue came up. So anyway, that's a discussion for another day. But in our last episode, we discussed a couple of recent decisions of the Federal Circuit and Family Court of Australia, and those decisions commented on AI and privilege. So both cases, similarly to the case you were referring to, James, they dealt with instances of court documents incorporating the use of AI such that incorrect information was disseminated to the court. But again, these key passages were just offhand comments rather than the determining crux of the case. So we've got one case, Helmold and Maria number 2, in which the court made comments that the input of documents arising out of the proceedings into a generative AI program which stores, collates and replicates data may waive privilege. They do go as far as to say these issues warrant extreme caution, but we have the word may waive privilege rather than will. Another case that relied on that Helmold case was from the end of last year, a case called Mertz and Mertz number 3. In that case, the court said that there was a risk that entering draft documents into an AI program will result in a breach or give rise to a waiver of legal professional privilege. Really, what we're seeing in Australia is the temperature of the courts is to caution against the entering of documents into AI for fear of waiving privilege, but it seems to only be a caution as it stands. The regulators are sort of in the same sort of vein. As I mentioned, there was a report in February, a Victorian Law Reform Commission report, that marked the first inquiry by an Australian law reform body about the use of AI in courts and tribunals, and similar to, I think, the report you were sort of referencing, James, and that had 30 recommendations with 8 overarching principles about the safe use of AI in courts and tribunals. And again, that has recommended commentary around closed and open AI, and that lawyers should not enter confidential, sensitive or privileged information into AI tools, but these are just recommendations at the moment. And similarly, the report did recommend encouraging uniformity of a stance, both within Australian courts and tribunals and even further abroad. So it will be really interesting to see how far Australia takes and adopts these recommendations, because as it stands, at the moment, these are just recommendations and these are just cautions. Thanks everyone for listening to part 1 of this episode, in which we discuss how AI and its impact on legal professional privilege is being approached in Australia compared with the United Kingdom. Having spoken to James Shiel of Mills and Reeve to canvass the position in the UK, and then refreshing ourselves on the position in Australia, part 2 of our discussion with James will unpack these differences and similarities between these two jurisdictions. We'll also discuss what is worrying litigators when it comes to AI and privilege, as well as some key takeaways to consider when using AI. As always, please get in touch with me if you have any questions about what we discussed today. You can find my details on our website, which is hallandwilcox.com.au, or please connect with me on LinkedIn. If you enjoyed today's episode, then rate, review, or subscribe wherever you get your podcasts. Thank you, and tune in to part 2 of our discussion regarding the UK and Australia, coming very soon.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.